No, you please don't do that.
The judgment which I said,
Someone may, you are right, but what about the order that is passed by the court and pursuant to which, if you are relying on this communication, which is at your instance, then how is the petitioner granted this benefit? Which is the order which is relied upon by your officers? Which is that SCA?
11061, which is mentioned.
Correct, but which is the order that is relied upon?
1910-2016, where it is stated that.
Then what about the order that is passed by this court?
May I read the order in which the complaint has been made?
Please read.
I am not disputing your lordship, but my point is that considering the order, payment has been done accordingly, the wage has been revised also according to the order.
Okay.
And accordingly, they are receiving the amount.
Correct.
Now,
Okay.
giving open the contention that they are working for less than 4 hours, the lordship may pass appropriate.
That is what I am telling you also. That is the only direction that is issued by the court and which we are inclined to, and rightly so, because otherwise you would not have granted the benefit to the petitioner has a petitioner ever been granted a benefit without the order of the court? The petition is pending at large.
Please, your lordship.
And you may share the order of 2016 also.
Lordships, may I request my friend to share that communication?
She should have shared it with you.
She is not shared it with me.
This is what I shared.
Communication.
Correct. So reliance is placed on the order passed by the coordinate of 2016. So that is what we are saying.
Please, your lordship. Therefore, this page 5 of the order which I shared.
Correct. And therefore, the same direction is given by the coordinate bench. The coordinate bench has passed the order relying on the order of 2016. Letters patent appeal. Honorable division bench. It would clearly appear that the petitioners would be entitled to the benefit of circular of 16/7/2019.
They are working more accordingly.
That is, the petitioners are entitled to grant of minimum pay scale with effect from so and so. The only liberty which is reserved is to verify whether they are correct. Now, on verification also, you must have verified and you have accordingly disbursed the amount, or what is the order that is passed by you? High Court na so and so, and then you are also saying a petitioner ne so and so मान चुका, and then they have kept the liberty reserved to challenge that order. So with that liberty, you have granted the approval.
Please have this.
That this Shikha Shah, right? Shikha Pancham. So this the communication takes care of the direction issued by the in 2016, and also the coordinate bench.
Please,
My lords, may I request that lordships may.
I'll just explain because she has been just served the copy.
Yes.
This is the name. प्रतिदिन काम न करला जेमा है ना दे करो this is
My lords, I've seen the communication that she's passed. Here it says that he's working for 2 hours. But there is an admission by them. If the 2016 order that is passed by this honorable court in the present matter, they themselves have admitted that the petitioner herein is working for 8 hours.
Correct.
If lordships may have that order only for a moment. 19th October 2016.
What is the date of this communication? This is of Mahe. This is of May 24.
Lordship, since I have not received, may I request my lords to keep it at 2:30, not to waste the honorable court's time, since I have not
because
that.
yes, we will have to consider, because this is a communication, or the calculation is of May 24.
I'll just go through it. Lordships, and keep it at 2:30.
Tomorrow. Miss.
I have just received it and I could print.
No difficulty.
Therefore, I could not share it.
I asked
for expected supplies. Ms. Suman Motla, the learned AGP, has placed on record communication dated 3/6/24 and submitted the name of the petitioner, figures and serial number 15 of the translate correct. And it is submitted that the petitioner hearing has accepted the amount. Ms. Shikha Panchit, the learned advocate appearing for the petition, to request for time to take instructions. Post the matter on calendar. Please, ma'am. Please. Oblige, ma'am. जरा જોઈ લેજો કઈ
Number 10 for order Mr. Vaibhav said.
3691 13/6 has the communication. The communication is dated 13/6. 3/6 છે કે 13/6 છે? 3/6. અને નાચ. One week up.
Number 11. The Rama Qureshi.
The petition challenges the GR of the state government, which is denying the benefits of 7th Pay Commission to the ad hoc faculties who are working on the post since more than 20 years.
Yes.
We were appointed as the assistant professors in the various degree engineering colleges on ad hoc basis, my lord, way back in the year 1998, 2001, and almost more than 20 years on this post they are continuing. And now due to retire also. They were at the time when they were appointed, somewhere at the time when 4th Pay Commission was there.
Correct.
Given the benefit of 5th Pay Commission, then given the benefit of 6th Pay Commission. And now when the 7th Pay Commission recommendations came, in the year 2020, the government came out with the GR page number 17, my lord, wherein at condition number 2, which is impugned, it is stated that Sarkari, condition number 2 at the bottom, lordship says that સરકારી અને અનુદાનિત ડિગ્રી ઇજનેરી અને ફાર્મસી સંસ્થાઓ અસ્તિત્વ ધરાવતી ફિક્સ પગારની તેમજ કરાર આધારિત તેમજ એડોક જગ્યાને 7મા પગાર પેન્શન લાભ આપી શકાશે નહીં. That is totally a stand-alone condition as to on what basis when you are giving them the past benefits. More particularly in view of the judgments of the Honorable Supreme Court, more particularly in the case of Jagjit Singh, State of Punjab, my lord.
Yes.
Paragraphs number 57, 58 and page number 60, para 60, when the Honorable Supreme Court says that as far as the equal pay for equal work doctrine is concerned, when there is no variation or difference in the nature of the work which the faculties are doing and are similarly situated, then there arises no reason to discriminate between the pay which has to be administered to them under the commission. Para 57 may be seen, my lord. Internal page number 222, lordship, somewhere in the last few pages.
Yes. Because what are the facts
Yes,
in the on the decision that you are relying on?
yes.
Yes. How are you seeking parity, or how are you relying on it?
Here the federation
What
of
was the issue
employees,
before the Honorable Apex?
yes, my lord, the employees who were appointed on a temporary, casual and daily wages, they approached the Honorable Supreme Court because they were being denied the benefits under the 6th Pay, 7th Pay Commission. higher pay scales in vis-a-vis in comparison to the regular appointees. So in view of that, the Honorable Supreme Court has laid down this ratio, wherein the Honorable Supreme Court has commented upon the concept of the equal pay for equal work by analyzing the several judgments of the Honorable Supreme Court rendered in the past cases,
Yes.
wherein the Honorable Court has said that tests that whether what are the nature of the work, the appointment done, duties and responsibilities shouldered by them,
Correct.
variation between that, and if the same are found to be similar
Yes.
and equal, then there arises no reason to deny the same. Therefore, in 57, the conclusion what the Honorable Supreme Court says is,
Yes.
there is no room for any doubt that the principle of equal pay for equal work has emerged from an interpretation of different provisions of the Constitution. The principle has been expounded through a large number of judgments rendered by this court and constitutes a law declared by this court. Same is binding on all courts in India under Article 141 of the Constitution. The parameters of the principle have been summarized by us in para 42 herein above. Principle of equal pay for equal work has also been extended to temporary employees, differently described as work charge, daily wage, casual, ad hoc, contractual, and the like. Legal position relating to temporary employees has been summarized by us in para 44 herein above. Above legal position which has been repeatedly declared is being reiterated by us yet again. In our considered view, it is fallacious to determine artificial parameters to deny fruits of labor. An employee engaged for the same work cannot be paid less than another who performs the same duties and responsibilities. Certainly not in the welfare state. Such an action, besides being demeaning, strikes at the very foundations of human dignity. Anyone who is compelled to work at a lesser wage does not do so voluntarily. He does so to provide food and shelter to his family at the cost of his self-respect and dignity, at the cost of his self-worth and at the cost of his integrity. For he knows that his dependents would suffer immensely if he does not accept the lesser wage. Any act of paying less wages as compared to others similarly situated constitutes an act of exploitative enslavement emerging out of a domineering position. Undoubtedly, the action is oppressive, suppressive, coercive, as it compels involuntary subjugation. And finally, reiterating in para 60, Lordship, the Honorable Court says, having traversed the legal parameters with reference to the application of the principle of equal pay for equal work in relation to temporary employees, daily wage employees, ad hoc appointees, employees appointed on casual, contractual, and the like, the sole factor that requires our determination is whether the employees concerned before this court were rendering similar duties and responsibilities as were being discharged by regular employees holding the same corresponding post. In our case, my lord, we are ad hoc assistant professors. Same duties, same responsibilities, everything same. With all respect, the respondents are unable to show as to what difference they can with regard to the duties which we shoulder vis-a-vis them.
Correct.
More particularly by their own conduct. Fourth pay was given, fifth pay was given, sixth pay was given. In sixth pay, they also instituted recovery, which was stayed by this honorable court that you can't. That order also I have annexed below. So there, now in the seventh page here, they cannot put up a condition in the resolution itself that no, ad hoc mate nathi. And even the wordings are also very surprising. If the condition number 2 wordings are seen, સરકારી અને અનુદાનિત ડિગ્રી ઇજનેરી અને ફાર્મસી સંસ્થાઓ અસ્તિત્વ ધરાવતી ફિક્સ પગારની તેમજ કરાર આધારિત તેમજ એડહોક જગ્યાને જગ્યા ઇઝ નોટ એડહોક. જગ્યા ઇઝ અ સેન્ક્શન ફોર એવરીબડી.
Yes.
એડહોક ઇઝ ધી અપોઇન્ટમેન્ટ.